A very warm and a good afternoon to all of you. We are once again back with another lecture in our lecture series, Justice for Rights Foundation lecture series. Today we have a very special guest and a very special topic. I have seen and I've heard and I have pondered over this particular topic for a very long time, and we at Justice for Right Foundation could not decide upon the perfect name. And then, like God sent, we found our guest for today, Senior Advocate Rebecca John, to discuss and teach us the intricacies of this topic. Before we start the lecture and I hand over the lecture to our guest for today, there are few instructions that I would like to give out. First of all, we are very sorry that certificates for our previous lectures were not delivered to you on time. Therefore, to rectify the situation, we have put and inserted a link in the comment section or the description section of this particular video, and we have titled it as Certificates for 30th April. So all you need to do is log on to it and send us your details, and we'll send across the certificates to you. Further, for these, since the live chat for this particular lecture is initiated, I request all of you to please maintain the decorum and to maintain a civil standard while commenting your opinions or asking questions. Before going further, I would attempt at giving a very short introduction to such an illustrious career that Senior Advocate Rebecca John ma'am has had. Ma'am joined the legal profession in the year 1990 when there were hardly any female criminal lawyers in the field. She was the first senior woman lawyer to become a senior advocate in the criminal law and designated as senior advocate in 2013 by the Delhi High Court. She has had a rigorous practice in Supreme Court, the appellate courts, and the trial courts in the area of criminal law. And she has handled various imminent cases, and I will attempt to name a few. Security scams of 1992, it was also known as the Harshad Mehta scam. The Hawala scam of 1996, wherein payments were allegedly sent by politicians through Hawala brokers. The Hashimpura massacre of 1986, wherein she appeared for victims in this case, in which 44 Muslims were targeted, murdered, and dumped nearby in irrigation canal by provincial armed Jawans. Anti-Sikh riots of 1984, where she represented victims. Ishrat Jahan encounter case, it was a criminal case in Gujarat in which Central Bureau of Investigation was accused Ahmedabad police and subsidiary intelligence bureau for fake encounter killings of 4 individuals. And then Delhi Diwali blast case of 2005, the Butler House encounter case, and then the most famous case that ma'am has dealt is the Arushi Talwar case, wherein it was an unsolved murder of a 14-year-old girl, Arushi Talwar, and 45-year-old Hemraj. Without further ado, I hand over this lecture to our respected and honorable guest for today. Ma'am.
Thank you. Thank you very much. And thank you for an opportunity to speak on a subject that should be of interest to all students of criminal law, and that is a journey of a criminal trial. Let me begin by explaining when exactly in law this journey begins. Most people tend to think that a criminal trial commences with the registration of an FIR or the presentation of a charge sheet. In fact, a criminal trial commences much later. A criminal trial commences at the time when the court dealing with the case frames charges against an accused person, and thereafter, all proceedings subsequent to the framing of charges will constitute the criminal trial. So proceedings which take place prior to the framing of charges, that is even including the period between the time the charge sheet is filed and charges are not framed, even that period does not constitute the period of a criminal trial. It would constitute the phase of inquiry. Prior to the charge sheet being filed, it would constitute the stage of investigation. So a criminal trial commences pursuant to the framing of charges. Let me begin by citing two judgments which will clarify this issue further. In Common Cause versus Union of India, 1996, Volume 6, SCC, page 775, the Supreme Court categorically stated that criminal trials commence with the framing of charges in a sessions triable case and the framing of notice in a magisterial trial. Even in a magisterial trial, uh, criminal trials commence either with the framing of notice or the framing of charge, depending on the procedure followed for the case. Likewise, in a subsequent Constitution Bench judgment of the Supreme Court in Hardeep Singh versus State of Punjab, 2014, Volume 3, SCC, page 92, the Supreme Court went on to say that uh, in cases of trials before the Sessions Court, the trial shall be treated to have commenced when charges are framed under Section 228 of the Code of Criminal Procedure. In cases of trials of warrant cases by magistrates, if the cases are instituted upon police reports, the trial shall be treated to have commenced when charges are framed under 240 of the Code of Criminal Procedure. While in trials of warrant cases by magistrates, when cases are instituted otherwise than on a police report, such trials shall be treated to have commenced when charges are framed against the accused persons under sections 246 of the Code of Criminal Procedure. In cases of trials of summons cases by magistrates, the trials would be considered to have commenced when accused who appear or are brought before the magistrate are asked under 251 of the Code whether they plead guilty or have a defense to make. So the idea behind this initial address is to state categorically that trials don't commence when charge sheets are filed. Trials don't commence when the police conducts investigations. Trials don't commence after an accused is summoned. Trials commence only when charges are framed. So that really is the starting point of the journey of a criminal trial. Having said that, it is important to quickly take into consideration the preceding steps, the steps preceding the framing of charges, so that we know how the structure works. So, as you know, criminal proceedings or a criminal case is initiated upon the registration of an FIR. Such FIR is registered under Section 154 of the Code of Criminal Procedure. The Supreme Court in Lalita Kumari versus State of Uttar Pradesh, 2014, Volume 2, SCC, page 1, has held that where the complaint discloses the commission of a cognizable offense, the police is duty-bound to register an FIR. Once an FIR is registered, and the offense under which the FIR is registered is non-bailable and cognizable, the police, of course, has the right to arrest an individual. The powers of arrest are incorporated in sections 41 to 60 of the Code of Criminal Procedure. The most important of these sections is Section 50, which mandates that the person arrested has to be informed of the grounds of arrest, and this is in consonance with Article 22 of the Constitution of India. Post-arrest and post the grounds of arrest being communicated to an accused person, the police under law has a right to keep an accused in custody for 24 hours under Section 57, and thereafter send the accused before a magistrate under Section 167. The field under which Section 167 of the Code of Criminal Procedure operates is known as remand proceedings. Now, after the first 24 hours, the magistrate must, in fact, the accused must, in fact, be sent to a magistrate who will then remand the accused person to further custody. These are in tranches of 15 days each. The first 15 days is interchangeable custody. And by interchangeable custody, I mean that within the first 15 days, the police has a right to take police custody multiple times. The accused can be sent to judicial custody and thereafter sent to police custody or vice versa. All of this is possible. Various combinations and permutations in the first 15 days After the first 15 days is over, an accused has to be necessarily remanded to judicial custody, and the accused will remain in judicial custody for a maximum period of 60 days or 90 days, as the case may be, depending upon the offense for which he or she is being charged. Of course, if the accused is granted bail, then the embargo of 60 or 90 days does not exist. The police will file its charge sheet within the time frame specified for offenses under Section 468 of the Code of Criminal Procedure. After the period of remand is over, and assuming that the police files its charge sheet, the next important stage is the stage of cognizance. What is cognizance? Cognizance has not been defined anywhere in the Code of Criminal Procedure, and judgment after judgment has attempted to decode the meaning of the word cognizance. Essentially, cognizance means that the magistrate for the first time applies her mind to the case presented before her by the police in the form of a charge sheet. But cognizance is not just taken on a charge sheet. Cognizance can also be taken on a private complaint or a complaint moved by a statutory authority. If you were to read Section 190 of the Code of Criminal Procedure, which deals with cognizance, 190 has three components to it. 191A deals with cognizance on a complaint, 1B deals with cognizance on a police report, and 1C deals with cognizance that the magistrate may take on his own. So cognizance, as I said, is a stage is a judicial stage. It is a stage when the magistrate applies his or her mind for the first time to the facts of the case, only for the limited purpose of initiation of proceedings. It is not the application of mind which is required at the stage of charge or at subsequent stages. This is only for the purpose of initiation of proceedings. Cognizance is taken once. Cognizance is by and large under the code taken by the magistrate. In special acts like the PMLA Act or the Prevention of Corruption Act or the Atrocities Act, cognizance is taken by the special judge and not the magistrate. But dehors those provisions of the special act, under general law, cognizance is always taken by the magistrate, even if the case is triable by a court of sessions. Once cognizance is taken, we move to the next stage, and that is the stage of copies, which is under Section 2. After cognizance is taken, we move to the next stage, which is summoning of the accused, which is Section 204 of the Code of Criminal Procedure. Once the accused is summoned, we go to the stage of copies, which is 207, where accused persons are entitled to the entire set of documents that the police seeks to rely upon. After copies, if the case is exclusively triable by the Court of Sessions, the magistrate does an important function, which is enumerated in Section 209 of the Code of Criminal Procedure, which is committal proceedings. The magistrate commits the case and the documents of the case to the Court of Sessions. Now, before I go further, it is important for me to give you a basic structure of the Criminal Procedure Code, where different kinds of procedures are followed for different kinds of offenses. And so let me try and decode that for you, because otherwise the understanding would be limited. Now, as I said, cognizance under the code is taken by a magistrate. Cognizance can be taken on a complaint. It can be taken on a police report. If it is taken on a complaint, which is a complaint that I may move individually as a complainant, or a statutory authority may move, for example, complaints under the Prevention of Food Adulteration Act or complaints under the Income Tax Act. The procedure to be followed here is what is by and large called in ordinary parlance the complaint case procedure. That is, cognizance under 191A, the magistrate then will ask the complainant to lead his or her evidence under Section 200, and then the summoning of the accused takes place under Section 204 of the Code of Criminal Procedure. Even after the accused is summoned under 204, if it is a case which is exclusively triable by a magistrate, there are different kinds of procedures which have been enumerated in the Code of Criminal Procedure. If the case is a summons case, that is a case where the punishment is less than 2 years or below, then a summons case procedure is followed, which commences from section 251 of the code, where the magistrate will, at the first instance, frame notice and not charge against the accused persons. The summons case procedure is from 251 to 259 of the Code of Criminal Procedure. Thereafter, if the case is punishable with imprisonment of more than 2 years, then the magistrate follows a warrant case procedure. Now, warrant case procedure is also divided into two different categories: warrant cases which are initiated on a police report, and warrant cases which are initiated on a complaint. Warrant cases which are initiated on a complaint, of course, the procedure is laid down from sections 244 of the Code of Criminal Procedure. In warrant cases initiated on a complaint, and remember, warrant cases are those cases which are punishable with more than 2 years of imprisonment, the complainant has to lead pre-charge evidence. This is the only exceptional circumstance where somebody gets to lead evidence prior to charge. In no other procedure is that allowed. In warrant case procedures, where the procedure is initiated on a complaint, the complainant has to lead pre-charge evidence. And only after pre-charge evidence is led can the magistrate consider the case for charge. This is as far as complaint cases are concerned. As far as cases initiated on police reports, or what we commonly call state cases. Now, here again, we make a distinction between cases triable by the magistrate and cases triable by the Court of Sessions. Cases triable by the magistrate, subdivisions can be made. Those which follow the complaint case procedures, where the punishment is 2 years or less. Those which follow the warrant case procedure, where the punishment is more than 2 years. The summons cases initiated on police reports, for example, an accident case, any case where the punishment is less than 2 years, the magistrate will follow the procedure laid down in the Code of Criminal Procedure from sections 251 onwards. Where it's a warrant case initiated on a police report, the magistrate will follow the procedure laid down from sections 239 of the Code of Criminal Procedure. So, and of course, where a case is initiated on a police report and is exclusively triable by the Court of Sessions, as I said earlier, the magistrate, after taking cognizance, after summoning the accused, after giving the accused all copies of the case, will commit the case under section 209, and after this committal, the Court of Sessions will take over the case and the accused who is sought to be prosecuted in the case. The Sessions judge, interestingly, post-committal, takes a second cognizance of the case, and this is again a nuanced exception to the rule that cognizance is only taken once and by the magistrate. If you were to read 193 of the Code of Criminal Procedure, it will become amply clear that the Sessions judge, upon committal, takes a second cognizance of the case. Soon after that, you come to the stage of charge. So all these processes, from arrest to cognizance, to summoning, to charge, differs from case to case, depending on whether it's triable exclusively by the magistrate or by the Sessions judge, one. Two, whether it's a summons. Even cases triable by magistrates have several different procedures, whether it's a summons case, whether it's a warrants case, whether it's initiated on a complaint, or whether it's initiated on a police report. So you have multiple procedures in the Code of Criminal Procedure prior to the stage of framing of charge, and these procedures are exclusive to the nature of case that the magistrate or the Sessions judge is trying. Uh, so therefore, let's come to this. Once the stage of charge is completed. Now, in a sessions case, based on a police report, the sessions judge uh, commences proceedings before him by allowing the prosecutor to open the case and by asking the prosecutor to justify his case as to whether the case of the prosecution warrants a charge against the accused persons. This begins from section 225 onwards. Section 227 gives the accused an opportunity to ask for a discharge. And the basic fundamental principles for a discharge is essentially two or three principles, which has been laid down by the Supreme Court in Prafulla Kumar's case, as well as in Dilawar Kalu Kurane's case, where the Supreme Court says that the judge is not supposed to go into a roving and fishing inquiry about the full length and breadth of the case, but will look at the case for the limited extent to find out whether a charge is a prima facie case is made out against the accused. Now, what is this test of prima facie case? The Supreme Court says that if, after considering the materials placed before it by the police, the court is of the opinion, one, that this is a case of grave suspicion, then the court is fully entitled to frame charges against the accused. But if the court believes that two views are possible from the evidence laid out by the police, and that although there is some suspicion against the accused, but not grave suspicion, then the court will be fully justified to discharge the accused. So these are the principles which have been enunciated by the Supreme Court for the stage of charge to decide whether an accused can be discharged or whether it is possible for a court to charge the accused and to move forward with the trial. Now, I'll just go a step backwards. I had talked about this is the sections 225, 226, 227 relates to summons case, relates to sessions trials where the case is exclusively triable by the Court of Sessions. However, not all cases are exclusively triable by the Court of Sessions. In a magisterial trial, for example, if it's a complaint case, then the procedure is that the magistrate takes cognizance, the complainant leads pre-summoning evidence, the accused is summoned. After the accused is summoned, assume that it is a summons case, for example, a case under the Negotiable Instruments Act, then notice is framed under 251 of the Code of Criminal Procedure, and notice is different from a charge in the sense that the section itself says that there is no need to frame a formal charge. You have to give the substance of the accusation to the accused and ask him whether he pleads guilty or whether he has a defense to make. Now, this language is peculiar to 251 of the Code of Criminal Procedure. In the case of a warrants case initiated on a police report, the magistrate can discharge the accused or frame charges against the accused under sections 239 and 240 of the Code of Criminal Procedure. In the case of a warrants case instituted on a complaint, the magistrate must record pre-charge evidence, and based on that, it can decide to charge or discharge the accused. So these are the multiple procedures that are followed by the magistrate and by the sessions judge, and depending upon the case before the magistrate or the sessions judge, the procedure has to be decided. Now, pursuant to the framing of charges, as I said, only after charges are framed does a criminal trial commence. So our topic today, the journey of a criminal trial, really starts with The journey starts with the framing of formal charges by the court. How are charges framed? That is, those provisions are from Section 212 of the Code of Criminal Procedure, where the court has to state the section under which a person is to be charged. The court has to state particulars of the offense, date, time, role, etc. Where where three or more instances emanating out of the same transaction in 1 year appears to have been committed, the court can have a common charge, etc., etc. So all of those provisions are, the court can modify, alter the charge. All those provisions are there from sections 212 to 219, 220 onwards of the Code of Criminal Procedure. Once charges, now let me take a sessions case. Charge is framed. As soon as a charge is framed under section 228 of the Code of Criminal Procedure, you go towards the stage of recording prosecution evidence. Prosecution evidence is recorded under section 231 of the code. This includes examination in chief, where the prosecutor will put forward his case by bringing a witness to the witness stand, and the accused has a right to cross-examine the witness, both these rights are incorporated in section 231 of the Code of Criminal Procedure. Once prosecution evidence concludes, that is, the prosecutor goes through his entire list of witnesses, exhibits all the documents that he wishes to exhibit, the stage of evidence is over. In Delhi, we have a practice where the court records the statement of the prosecutor, where he says that I conclude prosecution evidence. So you know that the stage of prosecution evidence is over. What is the stage after prosecution evidence is concluded? That stage is known as the statement of accused, recorded under section 313 of the Code of Criminal Procedure. The statement of an accused recorded under 313 is of particular importance, and accused persons must be mindful of the importance of this stage. 313 has undergone many changes. As of today, there is a fresh 3135, where the opportunity has been given to both the defense counsel as well as the prosecutor to jointly hand out questions to the court, so that no part of this process is exclusionary in nature. It involves both the prosecution and the defense. But what is the underlying consideration for recording statements under section 313? The underlying consideration is that every incriminating circumstance against the accused person must be placed before the accused person, so that he gets an opportunity to answer that whatever circumstance is placed before him. This statement, interestingly, is not a statement made under oath. It is a statement made without oath. That has consequences, and the consequences are, since it's not a statement made on oath, even if the accused were not to give correct answers, that alone will not constitute a circumstance against the accused at the time when the judge is making a final decision of the case. So this is an opportunity given to an accused by the court to respond to every incriminating circumstance which has come up in evidence during the time that the prosecution has led evidence in the case. It is a stage immediately after the prosecution evidence is concluded. It is a stage of critical importance, and very often the answers given by an accused person in his 313 statement are read by the court for purposes of deciding whether there is any scope for acquitting an accused person. And these answers must be consistent with the defense that an accused has taken right through the trial, and possibly any defense evidence that he will produce after the 313 statement is recorded. Once the 313 statement is recorded and every circumstance is put to an accused, even here, the law is that if an incriminating circumstance used by the court is not put to an accused, then it causes prejudice to an accused. So the whole idea of a fair trial is actually uh, is actually the basis of the 313 statement, that you give an opportunity to the accused to respond to every incriminating circumstance. If you have not put a circumstance to the accused, to the incriminating circumstance to the accused, you haven't given him an opportunity to respond to it. And if you haven't given him an opportunity to respond to it, you have caused him prejudice. And this alone sometimes becomes a ground for acquittal at the appellate stage. The parent judgment, as far as Section 313 is concerned, is the judgment of the Supreme Court in Sharda Birdi Chand's case, which really fully explains the stage of 313, among many other critical issues relating to criminal procedure code. But in particular, it focuses on the statement made under Section 313, the failure of the court to put important circumstances to the accused and the consequences of such failure. After the stage of Section 313 is over, the defense gets an opportunity to produce defense witnesses. In fact, one of the last questions that are asked in 313 statements typically from an accused person, there are 2-3 questions which are asked at the end. Why is this case against you? Do you have anything else to say? And the last question is, will you lead evidence in defense? So the accused is to make up his mind whether or not he wants to lead evidence in defense at this stage itself. Assuming there's no compulsion on an accused person to lead defense evidence, but assuming that an accused person wishes to lead defense evidence, then he has the opportunity to lead defense evidence in a sessions triable case under Section 233 of the Code of Criminal Procedure. And once the defense evidence is led by the accused. So the prosecutor gets a chance to cross-examine those witnesses led by the defense. Once defense evidence is led and completed, you come to the stage of final arguments under Sections 234, and then once final arguments are completed, the sessions judge passes his judgment under Section 235 of the Code of Criminal Procedure. This is the journey of a sessions triable case. Very typically in a murder case, this journey is followed in exactly this pattern. But what is a journey of a trial of a warrants case on a police report, Chapter 19, by a magistrate? Much of it is common, some of it is different. Once again, summoning takes place under 204, copies are given under 207, an accused can be discharged under 239, or charges can be framed under 240. Prosecution evidence is led under 242. 313 statements are thereafter recorded after the prosecution evidence is over, and under Section 243, defense evidence is led, post that final arguments and the judgment of the case. The trial of warrant cases on complaints, there's a slight difference here, because prior to charge, evidence is led. The accused has a right to participate in that evidence in the sense that the accused can cross-examine pre-charge at the stage of pre-charge evidence. Once charges are framed, then again the same process is followed, that of leading prosecution evidence, that of cross-examining prosecution witnesses, the stage of 313, the stage of defense evidence, the stage of final arguments, and then judgment. In the case of a trial of cases in summons cases, as I said, summons cases, no charge is framed. In summons cases, notice is framed under Section 251. Again, once notice is framed, you go through prosecution evidence, cross-examination, and in summons cases, sometimes the stage of 313 is not adhered to. Instead, magistrates invoke Section 281 of the Code of Criminal Procedure. If you were to read it, you will understand the difference between 313 and 281. In 281, a memorandum of the substance of the accusation against the accused is read out to the accused and he's supposed to answer it. It is not is not as detailed as a 313 statement. That is because these are less serious offenses, and the procedure is somewhat tighter and narrower in its scope. This essentially is the entire journey from charge to final arguments to judgment. However, in this journey, practitioners and accused persons and the prosecutor can invoke several provisions which can enhance his or her case. For example, Section 311 of the Code of Criminal Procedure. This is often used in a criminal trial by the prosecution and by the defense. If the prosecutor feels that a particular witness needs to be re-examined because he failed to elucidate to a particular fact or failed to prove a particular document or prove a particular fact, he can move an application under Section 311 for recall of such a witness. Likewise, an accused also has the right to ask for the recall of a witness of the prosecution whom he may not have cross-examined, or may have cross-examined partially, or may not have put something which is of critical importance to him. Normally, courts are liberal when it comes to allowing applications under 311. The only test that both sides have to fulfill is the test that the reason for the recall is in the interest of justice, and failure to allow the recall will cause grave prejudice to either of the two parties. Now, the law was pretty liberal on this topic back in the day. It has somewhat become tighter now, but essentially, courts are of the view that Section 311 parties should be given an opportunity at least once to employ this section, so that anything that was left behind inadvertently, which causes grave prejudice to the case of the prosecution or the case of the defense, the party should be allowed to employ this provision of recall so that the witness is recalled. In Natasha Singh versus CBI 2013, Volume 5, SCC 741, the Supreme Court said, and I quote, "The scope and object of the provision is to enable the court to determine the truth and to render a just decision after discovering all relevant facts and obtaining proper proof of such facts to arrive at a just decision of the case. Power must be exercised judiciously and not capriciously or arbitrarily, as any improper or capricious exercise of such power may lead to undesirable results. An application under Section 311 CRPC must not be allowed only to fill up a lacunae in the case of the prosecution or of the defense, or to the disadvantage of the accused, or to cause serious prejudice to the defense of the accused, or to give an unfair advantage to the opposite party. Further, the additional evidence must not be received as a disguise for retrial or to change the nature of the case against either of the parties. Such a power must be exercised provided that the evidence that is likely to be tendered by a witness is germane to the issue involved. An opportunity of rebuttal, however, must be given to the other party. The power conferred under Section 311 CRPC must therefore be invoked by the court only in order to meet the ends of justice for strong and valid reasons, and the same must be exercised with great caution and circumspection. The very use of the words such as any court, any stage, or any inquiry, trial, or other proceedings, any person, and such other person clearly spells out the provisions of this section have been expressed in the widest possible terms and do not limit the discretion of the court in any way. There is thus no escape if the fresh evidence to be obtained is essential to the just decision of the case. Likewise, another provision that can be employed at various stages of the trial is Section 91 of the Code of Criminal Procedure, where any of the sides, including a court, can invoke the provision to summon documents which are not in possession of any one party, which documents are important to prove the case, for the just decision of a case, to arrive at the truth. So Section 91 is another section which is employed by courts for the purposes of, during a trial, for the purposes of arriving at the truth. One of the landmark judgments of Section 91 has been given by the Delhi High Court in Motilal Vora versus State. It's a judgment by Justice Teji, where the only two requirements for invocation of Section 91 is necessity and desirability of obtaining the evidence that is sought to be obtained. A trial is really an attempt to arrive at the truth. The prosecution leads evidence in its favor. The accused has a right to rebut the prosecution case through cross-examination, through the employment of provisions like Section 91, and by giving his own version in his 313 statement, as well as giving his version through defense witnesses that he may bring in his support. An accused person can be a witness in his own case, in which case he invokes Section 315 of the Code of Criminal Procedure and takes the stand, this time not as an accused, but as a witness in his own case. When an accused person takes the stand as a witness by invoking Section 315, he will be administered oath, and he will have to meet the same standards of proof and credibility as any other witness. When an accused person takes the stand, the accused person must be mindful of the fact that anything and everything he says is subjected to cross-examination by the other side, either the complainant or the prosecutor, as the case may be. Very often, where accused persons take affirmative defenses, for example, alibi, or in the case of defamation, if the defense of truth is taken, or one of the general exceptions are taken, insanity, etc. Then in all those cases, it is important sometimes for the accused to be a defense in his own case. Certainly not an insane witness, but in all other circumstances, which I have stated, alibi, then you must prove your alibi. You must bring in defense evidence to show that you were not present at the time and place when the prosecution claims that you have committed the crime. As you know, Section 499 of the Indian Penal Code relating to defamation has a set of exceptions, special exceptions to 499. Some of them include truth, public interest, public good. So if an accused has taken the defense that what I spoke may have been defamatory, but it was the truth, and I made that disclosure in public interest and for public good, then the accused is entitled and must indeed come in his or her defense as a defense witness, as well as produce additional witnesses who may corroborate what the accused has said under Section 315 of the Code of Criminal Procedure. This really is the consolidated structure of a trial. While on the issue of defense witnesses, there is a general belief that courts disbelieve defense witnesses. That is actually not true. And the Supreme Court, in a judgment titled Dudhnath Pandey versus State of Uttar Pradesh, 1981, Volume 2, SCC, page 166, held that defense witnesses are entitled to equal treatment with those of the prosecution, and courts ought to overcome their traditional instinctive disbelief in defense witnesses. Quite often, they tell lies, but so do the prosecution witnesses. At the end of a trial, we must always invoke the first principles of any criminal trial. And what are those first principles? An accused is innocent till proven guilty. The standard of proof or the onus on the prosecution to prove its case beyond reasonable doubt does not shift, even in cases where the onus sometimes has moved to the accused person. For example, in a case of dowry death under Section 304B, the onus has shifted somewhat to the accused to prove his case. Even there, the Supreme Court has said the prosecution must lay out the contours of its case. And only after it discharges its burden will the onus shift on an accused person. So the initial burden always remains with the accused person, with the prosecution. The prosecution is supposed to prove its case beyond reasonable doubt. If it does not prove its case beyond reasonable doubt, the accused is entitled to be acquitted on grounds of benefit of doubt. In criminal trials in the recent past, electronic evidence has played a very important role. This is because in most cases now, the prosecution and the defense sometimes rely on call data, the location of a particular person at a particular time to enhance whether that person was there at the scene of crime, etc. Emails, WhatsApp communications, all of this has now entered the arena of evidence which can be proved during a criminal trial. Section 65B of the Indian Evidence Act is a section which must be read in toto. This is a section which makes it incumbent on the party leading electronic evidence to prove such electronic evidence, if led in a secondary form, by certifying that the evidence that they have led is of a nature that can be considered by court. And Section 65B gives the details of that certification. The person leading the evidence must certify that it is a genuine download from a electronic instrument. The instrument was in his possession, or he had general control over that instrument, that the instrument was in working condition and it has not been tampered with, etc., etc. So electronic evidence today is a very important component of most criminal trials, sometimes to prove a case, sometimes to disprove a case. If the prosecution's case is that a particular person was talking to a co-accused person in the course of or during the time the conspiracy was at foot, then the call data record of both these persons are produced to show that they were in constant communication with each other. On the other hand, if the accused person wants to refute the prosecution case is that the accused person was present at point A, meeting person B at the time of the commission of the offense. And he's able to show that, in fact, at that time, he was not at point A, he was at point Z, at his own home, far away from this other person, then that location of his cell phone tower will go a long way to disprove the case of the prosecution. The idea being, today, much reliance is made by both the prosecution and the defense on electronic evidence. And so this becomes a very, very important component of a trial. In murder cases, or in Prevention of Corruption Act cases, often you will have prosecuting agencies placing voice recordings which incriminate an accused person. These voice recordings, if they follow the pattern given in the Evidence Act, is admissible in evidence, and it then needs some effort on the part of the defense to refute the fact that the accused was not involved in the case. On the contrary, the accused may be in possession with voice recordings which prove his innocence, or which show that he has nothing to do with the crime for which he is being prosecuted. He too is entitled to place the same on record. Electronic evidence, therefore, has taken a life of its own and has now become a very, very critical part of the evidence led either by the prosecution or by the defense, and therefore particular importance must be paid to the certification under Section 65B, without which that evidence will not be taken as proved. Certain other important tips that, or important elements in this journey of a trial. Today, it is possible for the prosecuting agency to take the specimen handwriting of an accused person. It is possible for the investigating agency to take his voice sample that has been allowed by a judgment of the Supreme Court last year. It is possible for the investigating agency to make comparisons of handwriting and the incriminating voice recording they've got by taking the specimen handwriting or specimen voice samples and sending it to forensic laboratories and having a comparison of the two. DNA evidence has again become very critical in this journey of trial, particularly in murder cases, where this evidence, a DNA match, can sometimes be very incriminating and can sometimes lead to the conviction of an accused person. But even with DNA evidence, it is possible, if looked very carefully, to challenge the trail by virtue of which this evidence has reached forensic laboratories, to challenge the authenticity of the evidence. And all of this requires intensive cross-examination and intensive backroom checks, because while it is fashionable to say that there's a perfect DNA match, very often when we look at the case trail, we find that there is a lot of mismatch in the manner in which this evidence has been produced in court. At the end of the day, an accused has rights. Those rights must always be upheld because he is being tried for an offense. He has a right to a fair trial. He has the right to cross-examine a witness. He has the right not to be prejudiced during the trial. And keeping all of these rights in mind, trials ought to be conducted. So the journey of the trial, to conclude, commences with the framing of charge, proceeds to whichever stage we are in, or whichever procedure we are adopting. Essentially, a trial can be subdivided into these elements: charge, evidence, 313 statement, defense evidence, final arguments, judgment. Depending on whether it's magisterial or sessions court trial, whether it's warrants case procedure or summons case procedure, there are certain nuances that are introduced by virtue of different provisions and different procedures being followed, laid out in the Code of Criminal Procedure. But largely the structure of the trial is exactly this: charge, prosecution evidence, statement under 313, defense evidence, final arguments, and judgment. So this is really the journey of a criminal trial. In this journey, as I said, many other sections come into play, including the invocation of sections 311 and section 91 of the Code of Criminal Procedure. Sometimes evidence is recorded through commissions because the witness is not available before the court. Otherwise, the court is an open court and witnesses are recorded in the presence of the accused, the prosecutor, and the judge. But in some cases, commissions are allowed under section 285 of the Code of Criminal Procedure. Evidence must be recorded in court through a formal recording, but where the evidence is of a formal character, then you can invoke section 296 of the Code of Criminal Procedure, where through affidavits, evidence is recorded. This procedure is often used in Negotiable Instruments Act cases. That is also statutorily provided under the Act, where the evidence of the witness is recorded through affidavits. But in all other cases where the evidence is not of a formal nature, the invocation of section 296 is largely disallowed, because evidence is evidence which is recorded in court at the time when the witness is in court, in the presence of the judge, in the presence of the prosecutor and the defense counsel. There is no provision where he can make a pre-decided affidavit and place it as his evidence in chief. It must be spontaneous and it must be recorded as the trial proceeds. Really, this is the journey of a criminal trial. It's a pretty simple journey, and yet you can invoke many provisions to nuance your trial and what you do in a criminal trial. So some of those provisions I have spoken about. I'm happy to take questions if there are any with respect to this journey.
Thank you so much, ma'am. Thank you for explaining such a difficult, complex, yet an indispensable part of criminal law. We have come across a lot of questions have come to us from students and I think professors alike. The first question is from Shubham Kumar, and his question is, what are the procedures followed in preventive detention cases like UAPA?
Okay, so UAPA is not preventive detention, so we should get that out of our heads first. UAPA is a special statute. These are not. It's not a preventive detention case. It's a regular statute where the procedure followed is slightly different. Particularly, greater powers have been given by to investigating agencies. In my initial part of the address, I had said that the total period of remand in more serious cases is 90 days under Section 167 of the Code of Criminal Procedure. Under UAPA, the first remand, which otherwise is 15 days, can extend to 30 days. And the total period can extend beyond 90 days to a period of 180 days. The only caveat is that the prosecutor has to move an application at the end of 90 days to the judge stating that the evidence has progressed well, but there is still more evidence to be collected, and therefore an extension of time be given. So the period of detention prior to the charge sheet being presented to court can extend up to 180 days. Under UAPA, bail provisions are very, very stringent. Unlike sections 438 and 439 of the Code of Criminal Procedure relating to anticipatory bail and regular bail, there is no provision for anticipatory bail in UAPA. And even with respect to bail, that is where a person is in custody, once UAPA is invoked, the kind of provisions that Section 43 requires fulfillment are very, very onerous. For example, notice has to be given to the public prosecutor. The public prosecutor has the right to oppose the bail application. Well, that's common to both sets of cases. But more importantly, the court can only grant bail if he certifies that the accused has not committed the offense. From the evidence, it doesn't look like the accused has committed the offense, and it's unlikely that he will commit an offense of this kind in the future. Now, that's a certification which is almost impossible for a court to give, and therefore, Section 43 of the UAPA relating to bail provisions is very, very onerous. By and large, the trial follows the same set of stages. But it is the process and the punishment which makes the act quite draconian.
Thank you, ma'am. Ma'am, there is another question that has come to us, and it has come to us from Animesh. Now, Animesh asks, what is the procedure to stop the proceedings of proclaimed offender once he has declared as a PO, and what is the procedure for the same? I think he's just asking what is the procedure to stop the proclaimed offender proceedings once they are initiated.
Well, you have to challenge the proclamation order. Once somebody has been declared a proclaimed offender, that has to be challenged, and it's usually challenged in the superior court. There is no procedure as such. Who is declared a proclaimed offender? Somebody who has not been participating in the investigation or has not been attending court proceedings, that person is declared a proclaimed offender. So typically, you have to make yourself available before court. But if you make yourself available, then the court can take you into custody. So it's a kind of a challenge. It's a bit of a challenge what to do, and it's most lawyers struggle with that. Ultimately, it's you have to make a challenge against the proclamation order to a superior court by invoking either 482 or revisional powers, by saying that these were the reasons why you were unavailable before the court, and that you're ready and willing to be available. And then really it's discretionary as far as the court is concerned to cancel the proclamation.
Ma'am, another question is from Sonali Gambhir. Ma'am, you are currently dealing with the case of Priya Ramani. In our country, powerful people get a fair trial while common people fail to even the stage of trial. What are views on the same?
So what are you suggesting? Who's powerful here? Priya Ramani is facing a trial. She's not prosecuting. She's the victim of a prosecution. What is the question? Is it being suggested that Priya Ramani is a powerful person? I don't think so. She wouldn't be facing a trial otherwise. And you're saying in our country, powerful people get a fair trial? I'm not understanding this question. So are you suggesting that only people like Priya Ramani get a fair trial? We don't know. She's still undergoing a trial. Nothing is concluded so far.
So no, ma'am. No issue, ma'am. Another question is from Ma'am Srishti. IND is a party to UN Resolution 89 laying principle on effective prevention and investigation of extrajudicial, arbitrary, summary
execution. I just request participants to make lucid questions? I mean, this is an impossible question to answer. Please, can you just confine yourself to the lecture and make your questions clear? I am unable to understand the question or answer it. I'm sorry.
Okay. Coming to the next question, ma'am. Has magistrate have a power to direct police officer for registration of FIR in the non-cognizable cases?
Absolutely. That's a good question. Only the magistrate has that power. In non-cognizable cases, the police has no right to register an FIR. Under 155.2, if you were to read 155.2, in non-cognizable cases, the magistrate must, the police officer must take the consent of the magistrate before registering the FIR, the permission of the magistrate before registering the FIR. And while you're at on this topic, because it's an interesting topic and it might appeal to you, very often, in order to circumvent the requirements of 155.2, which requires that the magisterial permission must be taken before an FIR is registered in non-cognizable cases, police officers tend to add a cognizable section to non-cognizable offenses. So essentially the offense is non-cognizable, but just so that they don't have to go to the magistrate and take permission, they add a cognizable offense which is not made out. Now the Delhi High Court, in judgment after judgment, from Justice R.L. Gupta to Justice Siddiqui in Kansi Ram's case, have deprecated the practice of the police adding cognizable offenses to non-cognizable cases only to circumvent the need to take permission from the magistrate under 155.2. So yes, no FIR can be registered by a police officer for non-cognizable offenses unless permission is taken from a magistrate.
Another question is from ma'am hers. How lucrative is practicing on criminal side for a budding lawyer or a fresh graduate? Would you suggest a young graduate to choose this field, and what should they keep in the mind?
That's an interesting question. I wish I had a lucrative answer to that question. How lucrative is practicing? See, all practice. Are you a student of law, Harsh? If you are, then my answer is going to be this. All practice will take time, for you to establish yourself. I was a junior to a legendary criminal lawyer for close to 10 years. I didn't branch out before 10 years. And each day of those 10 years was a meaningful experience for me. So it wasn't particularly lucrative. I earned some money, not much. But as far as the learning experience goes, I am the kind of lawyer I am today only because of the fact that I spend that kind of time in training. No training must be underestimated. And it is my urgent plea to young people, don't just look at the lucrative side of practice. It takes time to learn. It takes time to watch. The only time that you can learn is by watching your seniors. And that's your greatest learning experience. And therefore, uh, it is not something you may get money as you progress in your professional life, but that should not be your only concern. I know I am being utopian by saying that. I know financial considerations are very important, particularly for younger people who may be coming from outside of the city, who may have to pay all manner of rents to stay for their offices, etc. But it is my urgent plea that don't make this the only consideration. Learning while training as a lawyer is so important. You build your strengths as a lawyer by watching senior people. I watch legends, and that is the reason why I'm comfortable doing trials and appellant work. And I watch legends not just for 1 or 2 years, but I watched them for close to 10 years. I assisted them in some of the landmark cases, and the experience and the learning you derive from those from watching those legends at work is irreplaceable. So just don't concentrate on the money aspect. It is important, but it is not the most important thing.
Another question is from Anurag, ma'am. So, is there any procedure in a CRPC to produce the additional witness and evidence from the side of accused when procedure of 313 been completed?
Is there any to produce it? No. Why would an accused produce an additional witness? The accused will produce defense witnesses. The question is not correct. Is there any procedure in the CRPC to produce additional witness? Why would an accused produce an additional witness? Prior to the stage, let me explain this. Prior to the stage
Okay.
of 313, you are looking at prosecution evidence. Now, after 313 is recorded, you are looking at defense evidence. So if you want to produce a witness, you will produce it in defense. You will not produce it it to assist the prosecution. You will produce the defense witness to further your own case. However, as I said, if you have not properly examined a particular prosecution witness, or if the prosecution has suppressed a particular witness, you can certainly invoke Section 311 and ask for the production and examination of that witness. So these are two different things. You will produce a witness who will enhance your case by invoking defense evidence. However, if you fail to fully examine or correctly examine, or if you've inadvertently not examined a witness properly, you can invoke 311 and ask for the recall of a prosecution witness.
Ma'am, there are so many questions related to RC murder case. So I do not want to put that question. RC murder case.
See,
RC Nagraj murder.
I really don't want to talk about it. The matter is still sub judice. The matter is, the appeal is pending in the Supreme Court against the acquittal. So we will not talk about cases which are still pending.
Okay. So now coming to the second question, ma'am. Part of the epidemic diseases ordinance 2020 presume an accused to be guilty until proven innocent. Is this prejudicial and ultra-virus? Which portion of CRPC apply?
When you say prejudicial and ultra vires, it's not the CRPC, it is the Constitution which will apply. Yes, even within the CRPC, The onus of proof in some cases has shifted. As I said, 304B is a classic example where the onus of proof has shifted. Now, as far as the Epidemic Act is concerned, it is being invoked in unprecedented times. So that is the defense of the state. As far as the recipients of the act is concerned, those who are being prosecuted under the act is concerned, they certainly have a case to say that the act is very onerous and the act shifts multiple burdens on the accused persons, and therefore it is unconstitutional in nature. You don't invoke the CRPC for that, you invoke the Constitution of India for that.
So there is another question from Subham. What is your views on a plea bargaining? Is this silver lining for courts or mockery of trial?
Very good question. I I hope I understand from where you're coming. Plea bargaining, especially in a country like India, should be used much, much, much more than it is presently being used. It's virtually lying in the doldrums. It's not being used sufficiently enough. And the section itself makes the usage of that provision quite redundant. The provision itself has become redundant because there's so many caveats to the provision. As you know, the more serious offenses you cannot have plea bargaining, and then there are multiple hurdles towards before plea bargaining applications can be considered. I think the whole procedure for plea bargaining should be liberalized in India, considering the load of cases we are doing and considering the number of cases pan-India which exist and which really should not exist anymore. And all of those cases, if the accused can bargain, then you should permit him to do so. Also, I think the Indian concept of plea bargaining is very different from some of the Western jurisdictions, because here it's predicated on the fact that you are pleading guilty to an offense. I'm not sure whether that is the right way to move forward. I think lawmakers may consider nuancing the plea bargaining sections where it is not obligatory on an accused to plead guilty. It is possible to bargain as far as the nature of an offense is concerned without pleading guilty. So I think there are many nuances here. I hoped when it was first introduced that it would take the load out of criminal trials. Unfortunately, it's very underused. It hasn't really achieved the desired result, and so I can't call it a silver lining. And I do hope that lawmakers look at those provisions again and make it more liberal than they are at the moment.
Thank you, ma'am. Ma'am, the next question is how a complainant comes to know that cognizance has been taken on his complaint.
Yes, good question. The magistrate very rarely writes, "I have taken cognizance of the offense." And so it's a matter of inference. You will get to know when the magistrate moves to the next stage. So suppose you have filed a private complaint against person A. The magistrate takes cognizance under 191A, but doesn't write in his order sheet that he or she has taken cognizance. However, the magistrate tells you to bring your witnesses, the complainant and his or her witnesses, on the next date of hearing. Clearly, the magistrate has moved beyond the stage of 191A and has moved to the stage of 200. That is the stage where the magistrate is asking the complainant to examine himself as a witness and to examine such other persons in support of his case as witnesses. So once you reach the stage of 200, it is to be presumed from the facts and from the matrix of the case that the magistrate has taken cognizance of the offense. Likewise, if it is a charge sheet and the police has placed the charge sheet before the court and the court summons the accused, then you know that cognizance under 191B has been taken and the magistrate has moved to the next stage, and that is summoning of the accused. So it is a very good question, and sometimes we also grapple with it because we don't quite understand what the magistrate has done, particularly if the magistrate has not moved to the next stage and it is not apparent from the record. But typically speaking, one way of finding out whether a magistrate has taken cognizance or not is to look at the next order sheet, to look at what the magistrate is asking to be done on the next date. If the magistrate is saying, produce your witnesses, or if the magistrate on a charge sheet is saying, summon the accused, it has to be presumed that the magistrate has taken cognizance of the offense, because those stages cannot be invoked till such time that cognizance has not been taken.
Thank you, ma'am. Ma'am, now we would like to proceed to the next part, and this is where we would just ask your opinion on a topic. And the topic that has come to us, we collected it from students, is that, or what is your advice to us, the young budding lawyers? Because there are a lot of practices that plague the criminal justice system. So what can be done on our side that we can maybe expedite or even help the justice system to run in a well-oiled manner as it was once incepted to be?
It's a complicated question. I'm very happy that you are engaged with something of such importance. I'm happy that as young lawyers you are asking that question. Well, let's first look at the onuses on lawyers. To make the system efficient, to make the system a system of integrity and a system which follows values and high principles. Well, the onus is somewhat on us. We must stop engaging in practices which go counter to those values. Practices where the first thing a young lawyer talks about is, should I be influencing the other side? Should I be influencing witnesses, etc., etc.? These are practices you should stay away from. In the 33 years that I practice law, I have stayed away from these practices. I sometimes don't know what my client is doing behind my back, and what I don't know, I don't engage with. But it is possible, even in today's world, as competitive as this profession has become, as corrupt as all of us have become, it is still possible to follow the straight and narrow path. And as young lawyers, that is my only advice to you. You will all achieve your levels of success in due time. You will all make it a lucrative practice at some stage of your career. All of that will come. But I think at the end of the day, you need to go home and sleep well at night. And the only way you can do that is being true to the profession. And the profession, the Advocates Act, demands that you follow ethical practices, that you do not deviate from the right path. And if you begin to do that from day one, you will never be tempted to do that at any stage of your life, no matter what temptations are placed before you. But to answer that question, it is not, the responsibility is not just on lawyers. Of course, a major part of that responsibility is on lawyers, but courts also need to be responsible to make the system an efficient, robust, value-based system. And so long as courts are disconnected with the pain of individuals, with what people in custody go through, no matter what crime people are accused of, one thing that criminal law teaches you, it is compassion. You become better human beings because you're seeing the pain of the individual. He may be accused of the worst crime, but it's not for you or for the judge to be judgmental, to pass value judgments on that individual. On the contrary, the graver the crime, the court must look for evidence carefully, because you might be putting away that individual for a dreadfully long period of time. Unfortunately, courts are not doing that. It's all becoming very mechanical. Courts are coming with preconceived notions. Courts are looking at cases from their own individual prejudices. And what is suffering is the concept of justice itself. Therefore, When you ask that question as young lawyers, my response is twofold. As lawyers, it is our responsibility that we follow ethical practices, that we are always prepared for a case, that we never let our client down, that we fight for the rights of our client till the very end. We don't abandon them midway. It is equally the responsibility of courts to respond in good measure. It is equally the responsibility of courts to follow the law, to show compassion, to not just look at the case presented to it by the police or the prosecuting agency as gospel truth, because we do know that in a large majority of cases, the police fabricates evidence, the police lies, there are political reasons why people are taken into custody. And if the court shuts its eyes to all of these factors, then we really have no space to argue for those people who face the long arm of the law unjustly.
Thank you so much, ma'am. Ma'am, I know we are stretching a bit, but there's one question that we can ask you. It's very important and it's pertinent from a practice that has evolved. It's on sealed cover. So we just want to know your opinion on this recent development of sealed cover, submitting evidence to sealed cover, and the effect it has, whether prejudicial or otherwise, on the accused and the whole fairness of the trial.
Okay. Justice must be open. Justice must be transparent. Justice must be unambiguous. Justice must be seen to be done, not just done. All of this runs counter to the newly evolved tradition of placing documents in sealed covers. If there are two parties to a litigation, both parties are entitled to know everything that is placed before a court. There is no when you are in court, there is no such thing as privileged information. And therefore, I am I'm very skeptical about this practice. I condemn it. I believe there should be no concept of sealed covers. It is unknown to other jurisdictions in the world. It is something which is peculiar to India. It must stop. And the sooner it stops, the better it is for all of us. As I said, everything done in court must be transparent. You may win, you may lose. That's a separate issue. Most of the time, if you may be on the side which is losing, never mind. But you and your client must get the feeling that we tried our best. Every information which was against us, we knew it, we countered it. If the court didn't accept it, fair enough. But if you don't even know what is that information which is being passed on secretly between the prosecuting team and the court, you have no way of countering it. It may be garbage, it may be humbug. How do you counter it if you are not aware of that information? So I deprecate the practice of sealed covers. I deprecate anything which is done surreptitiously, clandestinely. As I said, justice must be fair, justice must be transparent, justice must be open. That is why we have open court hearings. Everything that is relevant to a party must be known to a party. And if there is some communication which is happening between courts and one side, it is possible that the court says, I won't give you this information today, but I'll give it to you on the next date of hearing, because for the next 2-3 days, there's something critical happening. I don't approve of that either, but I can understand that. But forever and ever, if some bit of information is kept in a sealed cover and you have not had the chance to refute it, then it's a very unfair system. Then the whole platform is unfair. One side is, and the scales of justice are not equal. One side is in a privileged position, the other side is not. And therefore, what kind of justice is that?
Thank you so much, ma'am. Ma'am, I would like to tell my viewers one short information. I would like to give them this information that when we first contacted Rebecca ma'am for this lecture, her only consideration was whether there would be students or not. And I'm very proud to inform ma'am that I thank ma'am on behalf of not only our NGO, but also 560 students that streamed live to view her lecture, to watch her lecture, and to learn at the same time. Thank you so much, ma'am. Thank you for
I
your time.
cannot say how happy I am to hear that, because I believe students are going to take the baton from us. I believe they are our future, and if students can be trained to look at issues outside their textbooks and to look at it more holistically, to look at it from the point of view of natural justice, to look at it from the point of view of rights rather than simply statutory provisions, then there cannot be something more relevant and important. I am extremely grateful that so many students have viewed this lecture, and I hope I get an opportunity to talk to them again. Thank you very much.
Thank you so
Thank you
much,
so much.
ma'am. Thank you so much,
Thank
ma'am.
you.
Next
Thank
time, ma'am, I would like to invite on a very controversial legal topic of the court. So this time, because there are so many people, I have received the topics as well. But as we already had a discussion with you, so we could not arrange it. But they are again asking you to come on the board and again just deliver your lecture on the
All
same
right.
topic.
So
We will inform you very soon.
all right. Okay. Thank you very
Thank you so
much.
much.
Thank you.
Thank you so
Thank
much,
you.
ma'am.
Have
Thank
a
you
good
so
day.
much. All right. Before we bid adieu for this time, I would like to pass on this short information. We have another brilliant speaker for our next edition of lecture, and he is Shri Prashant Bhushan on the topic of constitutional and judicial evolution of human rights law in India. So this lecture would be on 9th May, and it would be streamed live on 3 p.m. All right. And before you guys leave and before we meet for the next time, the link to the certificates for 30th April has been mentioned in the description beneath this video. And all those students who have put up their names in this particular session for certificates, we will give you the certificates. We will try our best to send it over to you within 72 hours. So it's humbly requested to kindly bear with us for 72 hours. We'll make sure that you get your certificates. In case there is any issue with your certificate or anything else, or you have a topic that you would like to suggest, or is there something or a speaker that you would like for us to arrange for you, kindly send us an email on justiceforrightsfoundation@gmail.com. And at the end, but not the least, I would like to thank the team of Justice for Rights Foundation, our founder and president, Satyam Singh Rajput, our team who is working on the back end, Diksha Singh, campus ambassador and campus coordinator for Law Center 1, Gaurav Patel, our campus ambassador for and central counsel of Law Center 1, Diksha Singh, our campus ambassador from BHU, Utkarsh Sharma, our campus ambassador from the University of Gandhinagar. And in case I missed somebody, I'm very sorry. We have already stretched out for time. Thank you so much. We'll meet you for the next time. All the best and stay safe.